Hello, everyone. Welcome to today's session. On behalf of the International Malaysian Society of Maritime Law, it is my pleasure to welcome all of you to our webinar entitled Deadly LOIs. Is your LOI worth the paper it's written on? I'd like to introduce you to our esteemed presenter, Mr. Chirag Karya, Queen's Counsel. Mr. Chirag Karya is a leading commercial silk with broad commercial, international arbitration, energy, shipping, and international trade practice. He appears regularly in the Commercial Court, the Court of Appeal, and international arbitrations. He is listed as a leading silk for shipping and commodities dispute by Chambers UK and Chambers Global, the Legal 500 UK, and the Legal 500 Asia Pacific, Who's Who Legal, and the commercial disputes by Legal 500 EMEA. Now, Mr. Chirag Karya, being a Queen's Counsel and a barrister at Quadrant Chambers in the UK, his practice ranges from charter party disputes, insurance, bill of lading, and commodity disputes to complex oil and gas, share purchase, conflicts of laws, and arbitration matters. He also sits as an arbitrator, and most recently under the ICC, DIAC, and LMAA rules. He's a registered practitioner before the Dubai International Financial Center, or DIFC, courts, and teaches advocacy to barristers for Lincoln's Inn. And he has an impressive academic background. Chirag graduated from Cambridge University with the top first in his class, winning the Slaughter and May Prize, and achieved first-class honors in all three parts of the law tripos. Legal 500 describes him as an extremely intelligent, highly erudite, and tactically astute barrister, an excellent QC. So indeed, it's our honor to actually have such an esteemed speaker address all of us here under the auspices of IMSML's webinar. Now, before I pass on the time to Mr. Chirag Karya QC, can I just once again welcome all of you, especially if you're just joining. We are here for the webinar on Deadly LOIs. Is your LOI worth the paper it's written on? And I would encourage all of you to use the question and answer icon. If you have any question and answer for our speaker, please use it. We will have time for question and answers. We would like to post this question and answer to our speaker, and he'll be very happy to answer all your question and answers given the time slot that we have today. So on that note, I would like to warmly welcome Mr. Chirag Karya QC to present to us with his presentation. Chirag?
Thank you, Jeremy, for that very kind introduction, and thank you, members of the International Malaysian Society of Maritime Law, for tuning in, as it were, rather than turning up. I hope that this is a talk that can be both useful and interesting. As Jeremy said, what I'm going to be talking about is letters of indemnity and how they work, particularly with reference to oil trades, but in shipping generally, and in particular with reference to a case that I was involved in very recently, which is still ongoing, called the Tenacity. So what I'll do now is to share my screen so you can see the PowerPoint, hopefully. And so hopefully everyone should have my PowerPoint on their screen. And as I explained, I'm talking about letters of indemnity, the law surrounding it, and the fact that often they can give you a very false sense of security. And that's my reference to a particular case. So first of all, it's probably best just to look at the underlying law and practice. Now, I think a lot of us will know, if not most of us will know, that it's common practice, particularly in oil and oil product trades, for the cargo to be delivered without production of original bills of lading, because those bills of lading are still working their way through the banking system, payment having been made by way of letter of credit normally. And therefore, charter parties, both time charters and void charters will usually permit the charterer to order the owner to deliver without production of those bills, but against a letter of indemnity from the charterer. Now, the owner can do that, but the owner should be aware, and it indeed will be aware, that as far as the law is concerned, the law is perfectly clear that a ship owner who delivers without production of the bill of lading does so at his peril. So if it ends up that the person to whom the ship owner has delivered does not have the bill of, ultimately get the bill of lading, then the ship owner is going to be liable for misdelivery to the party that does have the bill of lading, which in almost all cases will be the trade finance bank. And you will know if you from the recent Hin Leung litigation, there is a large element of that in that litigation as well. And this particular case involves another insolvency, but here in the UAE, of a company called Gulf Petrochem. So as I explained, how do owners mitigate the risks of delivering without production of original bills of lading? Well, they do that by getting letters of indemnity from their charterers. Now, those letters of indemnity may give some comfort, and depending upon who your charterer is, may give you a lot of comfort. So if your charterer is Glencore or Trafigura or somebody like that, then the creditworthiness of the charterer will not be in doubt. But the first point is that as far as the LOI is concerned, it is not real security, it's simply a personal obligation, and therefore is only as good as the creditworthiness of your charterer. Now, there is also a risk that the LOI may not be enforceable, but that is a much smaller risk, because usually that will come into play only where the ship owner knows that, or is reckless as to whether the party to whom it is delivering is entitled to the cargo. Now, the other thing we will all know is that the P&I rules do not provide cover for liability for misdelivery, and therefore there is no automatic cover to the owner in circumstances where it has delivered against an LOI, but is then faced with a misdelivery claim by the holder of the bill of lading, usually a bank. There is a discretion in most P&I club rules for the directors to provide cover in their discretion, but as a general rule, such cover is not provided. Now, there is a risk of delivering to the wrong person and a risk of delivering to the right person, and I'll explain what I mean by that as I go through this talk. And I'll do that by reference to the decision, the litigation called the Tenacity, which was litigated last year and elements of which are still continuing to this day. Now, in that case, the owners of the Tenacity had time chartered the vessel to my clients, NOC Swiss, which was an oil trader based in the UAE. And NOC in turn had void chartered the vessel to Gulf Petrochem FZC, who I will call GP, which is a very large UAE company involved in the distribution, manufacturing, and refining of oil and oil products. The void charter provided for and bills of lading were issued in relation to gas oil shipped in Kuwait for discharge at Hamria in the UAE. In accordance with normal practice, the cargo was delivered on the 1st of May without production of bills of lading against back-to-back LOIs issued by NOC to the owners and by GP to NOC. And most of you will be aware that the practice in these circumstances is for the party at the bottom of the chain, in this case, Gulf Petrochem, to issue an LOI to NOC, and then NOC in turn to issue an LOI to the owners, pursuant to which the owners then deliver to the party designated in the LOI. Now, the gas oil's purchase price was 11.5 million and had been financed by Natixis Bank, which held the original bills of lading. Now, normally, the way this system works, as a lot of you will know, is the cargo is delivered to the ultimate purchaser. The ultimate purchaser pays the party at the bottom of the chain, which would be Gulf Petrochem, and Gulf Petrochem would reimburse its bank, Natixis. But what happened is that in the period before Natixis was reimbursed, a large internal fraud was discovered at Gulf Petrochem, and Gulf Petrochem came into severe financial difficulties, and indeed a chief restructuring officer was put in place. As a result, Gulf Petrochem did not and was not able to reimburse Natixis, and therefore Natixis, still holding the bills of lading, looked at the deepest pocket it could find, which was, of course, the ship. So in early August 2020, Natixis demanded delivery of cargo, or US $11.5 million, from the ship owners. The ship owners in turn called on my client's letter of indemnity, and we in turn called on the GP's letter of indemnity. Now, the first question was whether the LOIs were triggered at all, because both LOIs provided that the party issuing the LOI would lodge appropriate security, sufficient security, if arrest was threatened. Now, what Natixis, through their solicitors, did is they demanded cargo or money with express reservation of rights to enforce, quotes, without further notice to you. And the first question for the court was, did that amount to a threat to arrest? The court had very little difficulty with this question, explaining that the language used by Natixis' solicitors had to be construed in the context of the dispute as a whole and the whole claim letter. And it was obvious that what they were threatening was that the vessel would be arrested if the cargo or money were not forthcoming. Now, that left my client's NOC in a very difficult position, because the ship owners were thereby demanding some 13 million by way of security, consisting of the 11.5 million value of the cargo, plus about 1.5 million for interest and costs. Now, NOC, we asked Gulf Petrochem to put up that security, and Gulf Petrochem did not do so and said that it didn't have the money. As far as the owners were concerned, their focus was directly on my client's NOC, and they said, quite rightly, it doesn't matter that you provided the LOI in reliance on Gulf Petrochem's LOI. Whatever your motivation, you have an LOI and you have a clear obligation to put up sufficient security to prevent the arrest of the vessel. We argued that it was simply impossible for NOC to put up the security demanded, because NOC simply did not have the money. And in advancing that argument, I argued that firstly, equity will not act in vain, as we all know is a central principle of equity. And then the court could not and should not at least make an order that the defendant NOC could not comply with. We also pointed out that the court should bear in mind the very serious sanctions for NOC's failure to obey a court order. And in support of that argument, I relied on two cases, the Udall versus Capri Lighting limited case in the Court of Appeal, where the Court of Appeal explained that it is unthinkable that a court should put a man at risk of imprisonment by making an order which it knows at the time of making the order is impossible of performance. And we also relied on the dictum of Lord Bingham in South Bucks District versus Porter in the House of Lords, where he explained that given that the breach of an injunction is punishable by contempt, the court should only ever make an order with which the defendant can and reasonably ought to comply. Now, it's true that my client was not an individual and therefore could not itself be imprisoned, but nevertheless, imposing contempt sanctions on a company is an extremely serious step. And in accordance with the principle that equity will not act in vain, we argued the court should not order my client to put up money that it simply did not have. So how did the court respond? As you can imagine, the claimant ship owners were not very happy with this line of defense at all. And they first of all argued that it just simply wasn't a permissible line and that we had promised to put up sufficient security and that should be enforced. The court rejected the ship owner's argument, accepting the principle that we argued for, namely that it cannot and should not order a party to do the impossible, but it emphasized that the burden of proving impossibility was a heavy one and rested on the defendant alleging it, i.e. my clients. At one of numerous hearings, Mr. Justice Foxton held that the defendant relying on the impossibility defense must provide evidence of its assets and show what efforts have been made to provide as much security as can be provided, even if it isn't the full sum required. My clients, in response to that, offered and indeed paid $250,000 towards the $13 million security demanded, and the court, having initially issued an injunction, granted my client's permission to apply to set aside that injunction by proving it was impossible for it to provide further security. Now, this required a lot of financial evidence supported by, in our case at least, audited accounts, explaining what money the client had and where it had gone. And ultimately, after a couple of hearings, the court allowed my client's application to discharge the mandatory injunction to the extent over and above the $250,000 that the client had already paid. So that left the owners with only $250,000 security from the time charterers, NOC, whilst facing an $11.5 million claim from Natixis, and of course, additional costs in defending that claim as well. So here we have a situation where the LOI is perfectly enforceable, but the creditworthiness of the charterer isn't sufficient to support that LOI by the cash required. Now, I should say at the very outset that this is the first case that I know of where an English court has refused to enforce part of an LOI by way of mandatory injunction. As a general rule, the English courts have taken the view that LOIs should be enforced by way of mandatory injunction almost as a matter of course. And the question that arises, which may arise, is whether this creates a big precedent. Now, the same argument that we had raised against the ship owners was then raised against us by Gulf Petrochem, stating that it was unable to provide the security, and it explained its financial position by a witness statement from its chief restructuring officer, who had been brought in to restructure the whole organization. Interestingly, the court rejected Gulf Petrochem's defense on the evidence and issued a mandatory injunction requiring Gulf Petrochem to post security to prevent the arrest, even though the chief restructuring officer stated in his statement that that risked pushing Gulf Petrochem into liquidation. In fact, what ended up happening is Gulf Petrochem did not comply with those mandatory injunctions, claiming that they could not do so under UAE law, and summary judgment applications in relation to the claims against Gulf Petrochem are to be heard in December of this year. So this litigation is still ongoing. So what takeaways can we take from this case? First of all, owners delivering without receiving the original bills of lading do so at their peril. That principle should be, and I believe is known by all owners. Secondly, most letters of indemnity will be enforceable. It will be very rare where an owner would be debarred from relying on an LOI because there is some illegality, or because the owner was aware that the party to whom it was delivering was not entitled to the cargo. But of course, as in all personal obligations, the LOI is only worth the creditworthiness of the counterparty. And this is where I mention about the wrong and the right party. There's a risk not only in delivering to the wrong person when somebody else intervenes and takes the cargo, but even when delivering to the right person, because commercially, Natixis Bank, the last thing the Natixis Bank wanted was the cargo. It doesn't deal in cargoes, it's a bank. So the way the whole system is supposed to work and the way that Natixis wanted it to work was that the cargo should be delivered to Gulf Petrochem's buyer. Gulf Petrochem's buyer should pay Gulf Petrochem, and then Gulf Petrochem should reimburse Natixis. So the system actually worked exactly how the bank intended. And in that sense, one can say that the cargo was delivered to the right person by the owners. But nevertheless, they ended up on the hook of $11.5 million claim. Next point is the mandatory injunction is an extremely powerful remedy. And as I explained, as a general rule, the court will prima facie issue that remedy when enforcing and when being asked to enforce an LOI. But ultimately, we get back to the well-known statement that you can't get blood from a stone. You can't get money from a counterparty that simply does not have it. Furthermore, if that counterparty, as my client NOC was able to do in the tenacity, is able to prove to the court that it will not be able to comply with the injunction that has been requested, then the court will not issue it. However, it's important to bear in mind for anyone acting for charterers that the burden on proving impossibility is a very heavy one, and the charterer will have to provide full disclosure and compelling evidence to prove that impossibility. And in order to emphasize that point, as I mentioned, Gulf Petrochem itself was unable to satisfy that burden. And then picking up from the tenacity case, Winson Oil Trading, in a case brought by Scorpio later in early this year, actually in 2021, tried the same defense, and that was found to be wanting, and therefore the court ordered the provision of security despite the charterer's claims that impecuniosity made it impossible for it to provide and lodge the security required. So I've taken a very quick review of the applicable law, and hopefully by explaining it by reference to the concrete facts of the tenacity, that will provide helpful guidance to you and your clients. I'm now available to take any questions people may have.
Thank you, Chirag, for that very succinct and clear presentation on what seems to be a very interesting case. And it seems like quite a interesting exception to the general rule, where mandatory injunctions cannot be enforced in a situation like that for LOIs. Now, for those of you who are listening, you have the Q&A icon. I see a couple of questions already being asked, and I'll get to that. But if you have any questions, can you please type out your questions in the Q&A icon so that we can present it to Chirag? We are going to open the next 20 or 25 minutes for question and answers. So let's start off with a question here, Chirag, from Stephen Peterson. He's asking, if the ship owner knows that the person he's delivering to is not entitled to the bill of lading, will the LOI on standard wording say still be enforceable?
Right. So I'll just need to clarify the question. In these cases, the owner will know that the person to whom delivery is sought does not have the bill of lading. That's why he's getting an LOI. I think the question is, will the LOI be enforceable if the owner knows that the person to whom it's delivering is not going to be entitled to the cargo? And under those circumstances, no, it wouldn't be enforceable. But we just need to separate entitlement, ultimate entitlement to the cargo, and the entitlement to the bill of lading. The use of LOIs is so commonplace that even though the owner knows that the person to whom it's delivering does not have the bill of lading, that in itself does not constitute misconduct. What has to be proven is that the contract, in order for it to be unenforceable, has to be a contract to do something that is known to be unlawful. And it is not unlawful to deliver to the person you believe will be entitled ultimately to the cargo, and is only not entitled presently because the bills of lading are working their way through the banking system. So on the facts of the tenacity, there was nothing to put the ship owner on notice that this was anything different from the usual course of events, where the bills of lading would work through the system, would ultimately have ended up in the hands of Gulf Petrochem if you had waited for them to go through the system. Gulf Petrochem would have presented them to the ship owners and ordered the cargo to be delivered to Gulf Petrochem's buyers. So it's only if the ship owner has knowledge or is reckless as to misconduct that the LOI will not be enforceable.
Okay. Another question. In the tenacity case, it seems the bank was able to get the carrier to be guarantor of payment being made to the bank, which goes some way beyond the carrier simply agreeing to deliver to the right party, which is what the carrier seems to have done.
Yes. The carrier's obligation true legal obligation is to deliver against presentation of bills of lading. It's got nothing to do with delivering to the right or wrong party. If it gets the bill of lading and an original bill of lading and it delivers against that, then it has completed its obligation. And the point here is that it did not deliver against bills of lading. Now, the allied point, which seems to make this very unfair, which is what Stefan is referring to, is, as I mentioned, the owners did exactly what the bank expected the owners to do. And indeed, they did what the bank wanted it to do, because the last thing the bank wanted once the vessel came into UAE is for the ship owners to call up the bank and say, look, I've got your cargo here, come and take delivery. Right? The bank wouldn't have known what to do with, a ship full of oil. So how is it that the bank can have it both ways? How is it that the bank can, on the one hand, say, we don't want to get our hands dirty with the oil. We want you what we want to happen is for this oil to go down the chain to the ultimate buyer so that our client is paid and we get reimbursed. And at the same time, they say, oh, well, if you do that, we'll hold you liable. And the answer to that is that the whole system of LOIs is predicated upon misdelivery, predicated upon delivering without production of bills of lading being a misdelivery. So you can't really say that the bank agreed to waive its rights or consented to delivery, because the answer of the bank will be, yes, we only did that on the basis that there would be LOIs. And why is it, you ship owner, if you thought this was all perfectly acceptable and with the consent of the bill of lading, why did you ask for an LOI? You asked for an LOI because the law is clear and accepted that if you deliver without getting the original bills in return, you are at risk of being held liable for misdelivery. So I hope that answers Stefan's questions.
Yes. Well, I have a question of my own here. If everyone, including trade finance banks, know that oil cargoes are invariably delivered without production of the original bills of lading, can't it be argued that the bank consents to such delivery and therefore cannot claim that its cargo has been converted?
Yes, I mean, that's the precise argument that we were discussing. And in my view, it can't, because the system that is contemplated and agreed to by the bank implicitly is one which provides for the provision of LOIs. So it implicitly accepts that the owner is at risk of being liable to the holder of the bill of lading for misdelivery. And it is for that reason that the owner takes an LOI from his time charterer, and for that reason the time charterer takes the LOI from the voyage charterer.
See, all right. Thank you. We've got a question from someone. If we understand LOI is the protection for vessel owner for discharge without LOI, how about protection to charterer due to the short voyage and courier flow, where it might be impossible for LOI to reach the consignee?
I'm not sure I completely understand. The LOI would actually go to the ship owner. And the LOI would normally, you may not get the original LOI, but the LOI would often be scanned and sent over. And there is no magic generally in having the original, as long as you have a contract that's it's signed by the time charterer.
Right, yeah. I think we've got another question. What was the burden to prove or proof needed to prove impossibility of the creditors? I suppose what from a legal standpoint here, GPS was not successful in the same way that you were in showing financial impecuniosity, even though their chief restructuring officer, who gave evidence that even the company was at the risk of liquidation if they were to honor the LOI. So I guess from an evidential perspective, besides your powers of persuasion, Shirad, from an evidential perspective, what was the turning point for the judge in your case that allowed this exception here?
Right. So just to answer the burden of proof, well, the burden of proof is a balance of probabilities, but in order to satisfy that burden, the court will want to know that you've put all your cards on the table, and that you're not favoring one group to another. In our case, and as if you look at the report, there had been funds that had left the company, and there were claims against other parties in relation to those funds. But we were able to show the company itself only had a certain amount of money, and there were no other sources of funds whatsoever. You also need to be able to show that not only the company, but those behind the company, the officers, the funders, the big shareholders, would not put in money if the company was forced to put up the security. And so we had to go the extra step to say, not only does the company not have the money, but if you make the mandatory injunction, no rational shareholder would put in the additional funds, because those additional funds are going to go straight out of the company to the ship owner, and the shareholder will get no benefit whatsoever. And it wasn't as though the company had some phenomenal amount of goodwill or trade name that the shareholder would be commercially incentivized to keep the company afloat. So you've got to look at all of those issues. Ultimately, the judge has to be convinced, but the court will start with the presumption that you've issued an LOI, you've promised to put up security, and that's what we're going to make you do.
I suppose this dovetails into another question, which is the consequence of your success in the tenacity case that more charterers will be able to escape putting up security by pleading impecuniosity?
Well, I think certainly more will try. And as you saw, as I mentioned, there's a decision of Scorpio versus Winston Oil, and that's certainly what people tried. And in that sense, the tenacity case creates a precedent where this is possible. But I suspect the cases in which it is actually useful will be limited, because in order to persuade the court that you don't have the money, you have to put forward all your finances and explain precisely, why you don't have the money, and why, if an order is issued, the shareholders or backers of the company will not procure the funds so that the company is kept afloat.
Let's see.
Yeah.
I've got some general questions on LOI from the audience. I suppose a lot of them are commercial parties. So if you don't mind, I can ask a couple of them to you.
Sure.
We have one. Is an LOI enforceable in the event where the shipper indemnifies the agent carrier for any risk related to their cargo, specifically dangerous goods, where the shipper has not fully complied with regulations and the carrier finds out only after accepting the goods? I suppose it's quite a vague set of facts here.
Yes, I mean, I think, as I understand the question, the LOI is being issued by the shipper. The shipper indemnifies the carrier for any risks.
Yeah.
Well, yes, I mean, that would be the only circumstance. I mean, I don't really see why it wouldn't be. I suppose one would have an argument if the ship owner knows of the precise dangerous quality, but even then, it would simply be an allocation of risk, right? You and I know that we're transporting this type of coal, which has a liability to blow up. I, as the ship owner, says, I'm not very happy about carrying this. You, as the shipper, say, okay, I'll give you an LOI. Then at least as between us, I can't see any reason why that should not be enforceable. There may be some public policy issues if you and I know that it's on the verge of blowing up and it's likely to kill the crew or, create some vast and catastrophic environmental damage. But those are very extreme cases, which you wouldn't get in reality, because no ship owner is going to take on something that he knows is going to be dangerous.
All right. We have another question from Adeline Chan. Is bank guarantee LOI enforceable? Let's say we are the charterer and receiver provided us, let's say we are the charterer and the receiver provided us their financing bank guarantee LOI for cargo discharge. Until we charterer get protected from claims if receiver did not pay their financier eventually.
Well, yes, I mean, as I understand the question, it's their financing bank guarantee LOI. So by that, I mean, I understand an LOI that's countersigned by the bank. And you can get LOIs that are countersigned by the bank, in which case the bank is putting, their creditworthiness on the line. If that's the case, then you'll be fine as long as the bank is fine. But otherwise, you're reliant upon the creditworthiness of your contractual counterparty.
Yeah.
So
that would be the general position anyway.
Right. And in fact, I see Adeline sort of explains the next question. If the answer is yes, is that applicable to the same to bank endorsed LOI? Well, a bank endorsed LOI obviously gives you much greater protection because the bank is undertaking liability, or at least guaranteeing the presenter of the LOI's performance. So if in that case, the charterer or receiver is not able to put up the security, then you can go to the bank.
So we have an anonymous attendee who's asking a question. Does it mean that even though it's standard practice to deliver against a letter of indemnity in the absence of bill of lading, the ship owner always have to carry the burden of this delivery?
The answer to that, unfortunately, is yes. And it sort of seems very unfair. And indeed, what is very surprising, if somebody were to come and look at how international trade and shipping is carried out, you'd think that this was crazy, because every day, every minute, ship owners are delivering cargoes, knowing, or they should know, that they are at risk of being sued for the value of that cargo. And all they have to protect themselves is a piece of paper signed by their charterer, who may have lots of assets or may have no assets whatsoever. Yeah.
Well, just a follow-up question from the same person. LOIs sometimes refer to charterers recovering and delivering original bills back to owners in order to extinguish the LOI. Do charterers have an obligation to do so? And what is delivery? Sufficient to give the bills to the master or to the vessel agent?
It's very difficult to answer that in the abstract, because we really need to see the text of the LOI itself. But if the LOI provides that the bills of lading have to be delivered to the owners, then that will be a term of the contract, and it can be specifically enforced. If the charterer has the bills of lading, ultimately gets the bills of lading, then the owner can apply for a mandatory injunction or an order for delivery up. Whether it is sufficient, it would certainly be sufficient to deliver it to the master normally, but again, it would depend upon the wording of the LOI. As regards the vessel agent, that will be dependent upon the authority of the agent. I mean, in normal circumstances, you would provide the bills of lading to the vessel agent as a precondition to getting delivery. Whether in circumstances where delivery has already happened, the ship is gone, and the bills of lading are then coming to their charterer's hands, I think it would be debatable whether you could then just give it to the local agent, or whether what you should be doing is couriering them to the owners or the ship's managers.
We have a question from Dr. Irwin Hui. Hola, sir. Do you think alternatives to the LOI will become the norm in such transactions? Example, liability insurance or bank guarantees? And a second question, could delivery without production of the bill of lading be regarded as a mercantile practice in the oil trade and thus be an exception to the principle established in the Si Hai Tong case?
Right. So the first question, do you think alternatives? Now, I've not seen that many alternatives myself. I don't know what the commercial parties who are on this webinar have seen, but I've seen very few. I think banks are going to be reluctant to sign up on to any LOI without having counter security from their clients. We all know that trade finance banking is under a considerable pressure. A number of the big players have moved out of the field following the Hin Leong and indeed the Gulf Petrochem frauds. So whether there is any appetite within the banking industry to put their own necks on the line is I think very debatable. And again, one would expect that if a bank was willing to do so, it would want some counter security. Liability insurance, there is, I mean, you can get insurance for misdelivery. Ship owners can get that. That's in the market. It's not usually provided by P&I clubs, but I think some P&I clubs will sell that as an add-on. And so that's a matter for owners, whether they're willing to pay for that additional liability. And it may well be that cases like the tenacity make owners think twice, because so far, as long as everything works as it's supposed to work, then this isn't a problem, right? But the moment you have a break somewhere, and usually as a result of an insolvency or fraud, as in the Hin Leong or Gulf Petrochem situation, then the whole system stops working. And then you have lots of innocent parties fighting about a loss because the system didn't work as everyone expects it to work, and it works 99.99% of the time. Second question, could delivery without a bill be regarded as, well, I think that's extremely unlikely. And the reason for that is the provision of the LOIs itself shows that the mercantile practice presupposes the principle established in the Si Hai Tong case. So the whole system with a chain of LOIs is predicated upon delivering without bills of lading being a misdelivery. So there's no reason for the law to at least create an exception. Really, it's for commercial parties, either by way of insurance, bank guarantees, or some form of electronic bills of lading that go through the system quicker to come up with a solution.
Right. We'll just take a couple more questions. The trend is moving towards e-bill of lading, which will be no more which would no more be physically presented to get delivery. Will LOI still be workable under such circumstances?
Well, the question, I suppose, really is do you need an LOI under such circumstances? Will the e-bills of lading move faster through the banking system? I mean, one would expect that they would, because it cuts out the transportation time. It doesn't cut out the review time. So the issuing bank will have to review not only the bill of lading, but all the other documents that have been presented, the invoices, the certificates of quantity and quality. And so there is always that delay, but certainly the delay in transporting them, from the seller to the confirming bank, let's say, or advising bank, and then to the issuing bank, and then back down to the issuing bank to its customer, that will be shortened. So one would hope that that would reduce the circumstances where the bill of lading is not available at the discharge port.
And we'll just take one last question, Shirag. What about the responsibilities of the carrier to ensure that the shipper complies?
Yeah, I mean, it's not clear to me complies with what? With the LOI?
Yes.
So, I mean, this may be thinking about circumstances where the ship owner has received more than one LOI, which certainly happens. May get an LOI, and often you will have an LOI from the time charterer to the shipper, and one from the voyage charter to the time charterer, but whose terms are sufficiently broad to include the owner as well. Under those circumstances, the owner can go after whichever of those letters of indemnity that it wants. In fact, in our case, we did say to the owner, look, you also, if you look at the terms of the voyage charterers, i.e. Gulf Petrochem's LOI, you're entitled under that LOI as well. Why don't you go after them? And they said, look, we're not interested in doing that. We don't care that we've got additional remedies. We're going after you and we want the whole sum from you. So the fact that you have an additional person you can go after doesn't mean that the charter is not fully liable.
See, well, that is. Thank you very much, Shirag, for a very informative presentation on LOIs. I can understand why you entitled your paper "Daily LOIs." Is your LOI worth the paper it's written on? Because it really calls into question whether the enforceability and the value of an LOI these days. For those who are in legal practice, you may be interested to note that this case is reported. You can search for it in your English law journals online. I believe it's 2020 EWHC 3689 commercial. So you can look for the reported case and have a good read. On behalf of the International Malaysian Society of Maritime Law, we want to convey our warmest gratitude and thanks to Shirag Karya QC for giving us his time and sharing with us his experience. And I'm sure that everyone in the maritime fraternity, as well as the maritime legal fraternity, has indeed benefited from your presentation. So once again, Shirag, thank you, and we wish you a successful legal practice. And please stay safe during these most challenging times. Thank you, Shirag.
And thank you very much to you, Jeremy, to the International Malaysian Society of Maritime Law, and to all the stuff. There was 136 or even more people who attended, for taking time out of your busy schedules. I hope it was interesting and useful.
It was indeed. So on that note, everybody, we are going to zoom out now. All the best to all of you, and see you in our next webinar. Goodbye and stay safe, everyone.
Bye.
Bye.